Hi guys, welcome to Law Modules Made Simple and Comprehensive. I am Negricosa. Today I want us to look at Law of Persons PVL 1501. If it is your first time in here, please hit that subscribe button and please share with other students as well. Let us quickly check our question on our 101. Assignment 1, second semester. Do not panic. Oh, sorry. Do not panic. All first assignments have been moved. I'm talking about the submission dates. They have been extended, so do not panic at all. Do not forget to write your unique number and your student number. That is very vital, so that your script cannot get lost. And please remember that this assignment is the one that will grant you a seat in the exam center. So just make sure that you get on with it. Question 1. Trifina Baloyi, an unmarried woman who is also not a partner in a civil union, recently gave birth to a son, Jonathan. Her boyfriend, Daniel Kumalo, is Jonathan's biological father. She and Daniel approach you for advice about how to register the birth. Answer the following questions. A. They wish to register their son as Jonathan Baloyi Kumalo. May they do so? Explain with reference to authority. Okay, before we do anything, I want us to look at, I just want to quickly show you something. I want us to look at the keywords here. Our keywords are an unmarried woman. Oh man, how do we, yes. Unmarried woman or not in a civil union. I'm not going to highlight, it's just something that I want to show you quickly. And another thing is biological father. That is something that we need to look at. Yes. Okay. I also want us to look at our criteria. They have provided this assessment criteria for us here so that we can be able to see how our answer is supposed to be, how we are supposed to answer this question. It says there, correctly indicating whether they may register their son as Jonathan Baloyi Kumalo, providing authority, providing an explanation. By providing authority, they simply want us to provide the act, yes, act 123 of 19 what something like that. Okay, so now let us go to our study, our prescribed book, so that we can quickly answer our question. Another thing that I have noticed is that most of you are using the 4th edition. It states on our tutorial letter 101 that we must use the 5th edition. You see, the 5th edition. You must check your what am I doing? You must check your what? Your PDF, if you're using a PDF like me, that it is the 4th edition or the 5th edition, but the books are similar, like they are very much similar. They are very, very much similar. So there's really no difference, but maybe the page numbers may differ and all that. And the prescribed book that I have here, the PDF that I have here, because it is a scanned book, it is not really complete. So I try to find a complete PDF, or maybe you can stick with your 4th edition. I don't know, because I just think that they're very much similar. So okay, let us answer our question. It says here on our prescribed book on page 8. Okay, let me just quickly read the question again. It says they wish to register their son as Jonathan Baloyi Kumalo. May they do so? Explain with reference to authority. Okay. Our authority here is in terms of the Births and Deaths Registration Act 51 of 1992. There we have our 1 mark there. We have already provided authority. So our answer is below somewhere in the paragraphs here. It is very wise for you to read out everything there so that you can be able to understand what they're really talking about, so that you don't just look for the answer, read through so that you can be able to understand what's really going on here. So because of time, I cannot read through everything. I'll just read where our answer is supposed to be. So I'm just going to read this paragraph, and we are going to pick out our answers after that. This is page 10, if I'm not mistaken, of the prescribed book. Let me check. Yeah, it's page 10 of our prescribed book. Page 10 of our prescribed book, 5th edition, second paragraph. It says here, in case of a child who is born of parents who are not married to each other and are also not each other's civil union partners at the time of the child's conception or birth or at any intervening time, the birth is registered under the surname of the child's mother, unless the child's parents jointly request that the father's surname be used. The Birth and Deaths Registration Act does not make provision for the child's birth to be registered under a double-barrel surname consisting of both parents' surnames. If the child's birth is to be registered under his or her father's surname, the father must acknowledge paternity in writing in the presence of the person to whom the notice of birth is given and enter his particulars on the notice of birth. A father who wants to acknowledge paternity and enter his particulars after the child's birth has been registered may do so with the consent of the child's mother. If the mother withholds consent, the father may apply to the High Court for a declaratory order confirming his paternity and dispensing with the mother's consent. Once the particulars of the father have been entered, they may not be changed without conclusive proof being presented that the changed details are those of the person who actually is the child's father. The objective of the latter provision is mainly to restrain parents from registering their child's birth under one father's surname and subsequently falsely changing their father's details to those of another man in order to enable the new father to obtain a South African immigration permit. A gamete donor and the father of a child who was conceived as a result of rape or incest may not have the child's birth registration amended to identify him as the father. So here our question is requiring us to advise Daniel and Trifina whether they can be able to register their son Jonathan as Jonathan who Kumalo Baloyi, something like that. That is a double barrel surname, which means that the surname it consists of both parents' surnames. I don't even know what I'm saying, but something like that. Okay, it says here, in case of a child who is born of parents who are not married to each other, our couple here is not married and they are not each other's civil union partners. So the birth is registered under the surname of the child's mother, unless the child's parents jointly request that the father's surname be used. The Birth and the Death Registration Act does not make provision for the child's birth to be registered under the double barrel surname consisting of both parents' surname. I don't think I have to explain anything here because everything is just on the table, black and white. Our criteria there says that we must correctly state whether they may register their son as Jonathan Baloyi Kumalo. Our answer should be like this. I'm not saying that you should copy what I'm saying. I'm just giving you an example. You must put everything in your own words. No, they cannot register their son as Jonathan Baloyi Kumalo. Then now we need to refer to authority. We say that the Births and Deaths Act 57. What? No, I'm crazy. The Births and Deaths Registration Act 51 of 1992 states that, or it says that, or whatever, then you provide your explanation saying everything that it does not make provision for the child's birth to be registered under a double barrel surname. Just explain everything that is written there. So let us go to our second question. We will start by looking at our assessment criteria. It says correctly indicating whether they may register their son as Jonathan Kumalo, providing reasons. Question 1b. They wish to register their son as Jonathan Kumalo. May they do so? Provide reasons for your answer. Here we are not asked to provide authority, but to provide a reason. Our answer is supposed to be like this. Yes, they may register their son as Jonathan Kumalo, which is his father's surname. Then when we provide an explanation or our reason, our answer should be if the child is to be registered under his or her father's surname. Okay, it says there, if the child's birth is to be, okay, let me just try to highlight, this is a scanned, what am I doing? This is a scanned whatever. So I don't even know how to do this, man. Okay, yeah, I'm reading somewhere there, ne? If the father, if the child's birth is to be registered under his or her father's surname, the father must acknowledge paternity in writing in the presence of the person to whom the notice of birth is given and enter his particulars on the notice of birth. That is our answer right there. So there we have provided our reasons, but remember to always put everything in your own words. The third question, not even the third question. C. Okay, let us check our criteria. Recognizing and identifying whether this question differs from the previous one, providing a reason for your answer. It says there, would your answer to B have been different if Daniel had raped Tryphena when Jonathan was conceived? Provide a reason for your answer. Our answer should be like this. Yes, they may. Yes, my answer on B would have been different if Daniel had raped Tryphena when Jonathan was conceived. So when we provide our reason, we say that a gamete donor and the father of a child who was conceived as a result of rape or incest may not have the child's birth registration amended to identify him as the father. So I just want you to see where I am reading. That's why I read out everything. But the real thing here is that the father of a child, you see my arrow, the father of a child who was conceived as a result of rape may not have the child's birth registration amended to identify him as the father. You do not have to necessarily copy what is written there. Just answer the question accordingly, use your own words. I always say this. Okay, second question. Question 2. Amanda, who is 6 weeks pregnant, wants to terminate her pregnancy. She is concerned that the termination of pregnancy might contravene Section 11 of the Constitution. In your own words, explain to her what right this section protects and whether the termination of her pregnancy contravenes this section. In your answer, you have to refer to authority. Our criteria first, we do not have to forget that. That is very important because it gives us guidance on how we're supposed to answer our question. It says there, correct description of Section 11 of the Constitution, correctly indicating whether the proposed termination of pregnancy contravenes Section 11 of the Constitution. Reference to authority. Case name. I'm using the study guide right now because I just want to quickly show you how the study guide works, or how it refers us to the what the prescribed book, because many people think that the study guide is useless. Sorry, I mean useless. So they don't really use it, but it's quite it makes things very simple. It's quite convenient to use the study guide because it refers you to the correct page on the prescribed book. So it says here, termination of pregnancy. Hitting indicates on page 20 that termination of pregnancy is not an instance where the fetus interests are protected by the necessitarius fiction. The necessitarius fiction can obviously not be used because an aborted fetus will never be born alive. Okay, let us just check the definition of necessitarius so that we can understand what we are really talking about here. Okay, it says here definition and requirements. On page 12 and 13, Heaton pays attention to the meaning of the necessitarius fiction and the requirements for its application. A necessitarius is a conceived but unborn child. If you want to, you may also use the term fetus instead of unborn child. There we have our clear explanation now. We know exactly what we are dealing with right now. Let us go back to our question. I'll just read everything there so that we can just slide to our prescribed book. Circumstances in which a pregnancy may be terminated. An abortion is now regulated by the Choice of Termination of Pregnancy Act 92 of 1996, which legalized abortion. On pages 20 and 21, Heaton discusses the rules regulating the termination of pregnancy during the following periods. During the first 12 weeks of the gestation period, from the 13th up to the 20th week of the gestation period, after the 20th week of the gestation period, you are going to further go down with it by yourself just to save time and all that. You're going to read everything on your own. Let us slide to our prescribed book. One thing that I want to say to you first is that when they talk about Section 11 of the Constitution, they are talking about the Termination of Pregnancy Act 92 of 1996. So do not be confused there. I'm not going to read out everything there because we already got a summary of everything on the study guide. So I will just read out the most important stuff there. It says there on our criteria that we must give the correct description of section 11. Okay, it says here, this is where I'm reading, guys. Here, I'm reading here now. Yes, the choice on Termination of Pregnancy Act 92 of 1996 permits termination of pregnancy on demand during the first 12 weeks of the gestation period and on several grounds, including socio-economic considerations. Economic. After that, regrettably, the Act does not provide for compulsory counseling before or after the termination of pregnancy. Okay, let us not waste time. Our question states clearly that our Amanda is 6 weeks pregnant. So it says there on the act that you are permitted to to make an abortion on the first 12 weeks. So she is 6 weeks, then she is safe. She is what she is still allowed. She can do she can make an abortion. She is not contravening with the Termination of Pregnancy Act 1992 of 1996. So she is allowed to make an abortion. So it further says the reference to authority, case name, where it says consent on our study guide. I don't even know what page is this, but I think it's the very same page that we were doing. Page 32 below. It says Christian Lawyers Association versus Minister of Health 2005 deals with this issue. We don't have to read any further. There is our answer right there. That is the case name. We have already referred to our authority. So we are good. We are sorted. We have, I think we have covered question 2 fully. If you don't understand, hit me up on the comment section. We'll see what to do. Question 3. James Amalo's wife, Christina, has been missing for 6 years. He would like to approach the court to grant a presumption of death with regard to his wife. James approaches you for advice about the following. A. Which presumption of death procedure, common law or statutory, will be applicable under the circumstances? Okay, first, we need to first understand what are we really talking about when you talk about the presumption of death. So, I don't even know what page is this of our study guide, but I checked the definition of a presumption of death on our study guide. Let me just read out everything to you, then I'm going to give you the page after this. It says here, we then discuss the end of legal personality, namely at death, and explain the special rules of presumption. Oh man, this is not what I'm looking for. Oh yeah, it is. Okay, we then discuss the end of legal personality, namely at death, and explain the special rules of presumption of death that are applicable when a person disappears and it is uncertain whether he or she is still alive. So, presumption of death is when we are wondering whether a person is still alive or not. When a person goes missing or a person disappears, something like that. I don't even know what page is this. Let me first check the page of our prescribed book. Okay, page 28 of our prescribed book. That's where we are going to read about presumption of death. It says there, if a person disappears and there is no certainty as to whether he or she is dead or still alive, a presumption of death can be pronounced in terms of the common law or in certain instances in terms of statute. Common law procedure. In terms of the common law procedure, any interested party, for example, a creditor of the missing person or the person's heirs or surviving spouse or civil union partner, may approach the High Court in whose jurisdiction the missing person was domiciled at the time of his or her disappearance to grant an application for an order presuming the person's death. The case is brought by way of an application. The applicant must prove on a preponderance of probabilities that the missing person is dead. Initially, our law followed the English rule according to which an order presuming a person's death is granted after an absence of 7 years. This was superseded by the rule that no fixed period of time is required. Naturally, the length of a person's absence is a factor that is taken into account by the court and it can even be decisive, but it is not the only factor. As the court indicated in Ex parte Estate Russell, other factors are also relevant. Before coming to any conclusion, the court must take into consideration certain factors: the age of the person presumed to be dead, the length of his absence from home, the trade or occupation of such person, whether he followed an ordinary peaceful occupation or whether he was engaged in a business or trade to which ordinarily risk or danger was attached. But he was engaged, but in the absence of any evidence to indicate that the absence. Sorry. Okay, my battery died. It did not even die. It was complaining. Sorry. Okay, I don't even know where to start, but I can start from the top. Yes, I'll just start where it says but with the 3 dots there. But in the absence of any evidence to indicate that the person presumed to be dead was engaged in an occupational endangered life, the mere fact of his not having been heard of for any number of years is not sufficient to authorize the court to come to the conclusion that his death must be presumed. On occasion, even an absence of 30 years was considered insufficient reason for pronouncing a presumption of death. In contrast, the presumption can be pronounced after a short absence if the probability of death is very strong. It further says there, the fact that the missing person would have reached an advanced age at the time of the application can be important, as can the fact that the person was in bad health at the time of his or her disappearance, or that he or she manifested suicidal inclinations. A person's death is not presumed lightly, and it is thus required that the applicant bring all the relevant facts and circumstances to the attention of the court. It has apparently become firm practice for the court After hearing the application to set a return date on which the final order will be made, the applicant is then ordered to give a return date on which the final order will be made. The applicant is then ordered to give a notice of the rule, NICE or NICE, whatever that word is, to those interested parties indicated by the court, and to publish the rule NICE in the Government Gazette and a newspaper in circulation in the area where the missing person used to live. This enables other interested parties to object to the granting of the final order or to bring further facts to the notice of the court, which could either rebut the presumption of death or strengthen it. Okay, so our answer here is common law procedure or common law presumption of death. Okay, let me just remind you the question. The question is A. Which presumption of death procedure, common law or statutory, will be applicable under the circumstances? The answer is common law procedure. B. Who may approach the court to grant such an application? It says here common law procedure. In terms of the common law procedure, an interested party, for example, a creditor of the missing person or the person's heirs or surviving spouse or civil union partner, may approach the High Court in whose jurisdiction the missing person was domiciled at the time of his or her disappearance to grant an application for an order presuming the person's death. The case is brought by way of an application. Okay, there we have our answer. But I also want us to look at the our study guide. We are going to read under summary of the differences between the common law and statutory presumption of death procedures. I'm not going to read them. I am going to just show you this table. You can go through it at your own time. It is a very helpful table. It says here who can apply, or maybe I should just have to start here from the start. We are going to read under common law presumption of death. It says when a person is missing and there is no certainty as to whether he or she is dead or still alive. So you are going to using this table, you are going to understand why I chose common law presumption of death and not statutory presumption of death. I chose common law presumption of death because statutory clearly shows that it's when you are sure that a person is dead. So on our scenario, Mr. Ngumalo is not sure whether his wife is dead or not because the wife has been missing for 6 years. It's not like he knows that his wife is dead, but the wife has just disappeared. He doesn't know her whereabouts. He doesn't know whether the wife is still alive or not. So common law deals with presumptions, like they're presuming if the person is dead or still alive. Okay, I got to this table because I wanted to show you where it says who can apply. Any interested party, such as a creditor, heir, or surviving spouse or civil union partner. You see that the study guide works hand in hand with the prescribed book. Don't think that the prescribed book is useless or something. They have just summarized the information here. So I'm sorry. It's very wise to use both books, the study guide and the prescribed book as well. Okay, our question further says, let me just go to our 101. What is the procedure to obtain a presumption of death order? This is our answer here on 2.5.1 common law procedure. I'm not going to read out everything there because I have just written it out. I have just read it out. So yeah, this is our answer here in terms of the common law procedure. Yes. That is where you are going to get your procedure there. Just try to summarize it in your own words or paraphrase or whatever. D. What will happen to Christina's estate if the presumption of death is pronounced? On page 31 of our study guide, of our prescribed book, it says B. Distribution and administration of the missing person's estate. After a death has been presumed, the person's estate may, in principle, be dealt with as if he or she were dead. Thus, his or her estate can be administered and divided among his or her heirs. The courts have, however, on occasion adopted a cautious attitude and have ordered that while the estate may be divided, the heirs must furnish security for the restoration of the property or its value should the missing person return. If the court decides that the circumstances of a particular case do not justify granting an order presuming death, it may nonetheless order that the missing person's property be divided among his or her heirs, providing that they furnish sufficient security for the return of the property or its value, should the missing person reappear. The court may also appoint a curator bonus to administer the missing person's affairs without pronouncing a presumption of death. So here we simply have to say James will inherit Christina's estate since he is the spouse, and it was not mentioned there that he has kids or whatever, So you're going to just give a small summary of this. Just try to shorten it up and also state that James is the one who will inherit the what the estate, Christina's estate. Yes. E. Suppose that the presumption of death has been granted. James now wants to marry his girlfriend, Nikki. What does he need to do to dissolve his marriage to Christina so that he may marry Nikki? Explain the legal position to him. In your answer, you have to refer to authority. Let's check out our criteria. It says, question 3A. Explain legal position with regard to dissolution of marriage, referring to relevant authority. So these are the things that we need to So these are the things that we need to look at when we give out our answer here. It's on page 45 of our study guide. It says effect on marriage. The marriage of the missing person is not automatically dissolved, but the surviving spouse must bring a separate application in terms of the dissolution of marriage and Presumption of Death Act 23 of 1979 in order to dissolve his or her marriage or civil union. So you just have to try to explain there and look at on your scrapbook as well, so that you can have other points to add there. And the authority that we must refer to is the Death Act 23. It's the dissolution of marriage on presumption of death